Okay, hello and welcome everybody. I think this is a good moment to start. This is the afternoon session of the EMLE Midterm Meeting 2022, and it's a great pleasure to introduce today's keynote address. The field of law economics is full of interesting people, but I'm delighted to be able to welcome one of its superstars, in the name of Katharina Pistor, who really is one of those persons who doesn't need any introduction. She is a phenomenon because she is not really just law. She's not really just law and economics. She's not just law and political science, but she is somehow all of it. She is one of those, I think, generalist superstars who really is familiar, one universal scientist, if you like, who is really looking over across many of these different disciplines that we're all interested in. Formally speaking, she is the Edwin B. Parker Professor of Comparative Law at Columbia University. And a few words of background, because people might be interested in her career. She originally studied law in Germany, in Freiburg, if I'm not mistaken, and then did the second state exam in beautiful Hamburg. She is somehow connected to at least some places that are involved in the EMLE program. But ever since, she's been oriented towards the United States and made a fabulous career in academia. I think all of it at Columbia, actually. You never changed. But it's great to have you with us here. Katharina's work really spans areas as diverse as corporate governance, financial regulation, law and finance, but also property rights, law and development, and comparative law and comparative institutions more generally. She is, of course, most well known for her recent book, The Code of Capital, 2019. I'm sure that most, if not everybody, has read it, and it's a fascinating account of basically how law can be used, how law can be instrumentalized, let's put it in a neutral way, for creating certain economic conditions and, most importantly, inequality. And I understand that today's talk is sort of building up onto that theoretical groundwork. So, Katharina, thank you so much for taking the time and being here with us. Just the modalities, she will speak for roughly 30 minutes or so. There is ample time for Q&A afterwards. Because this is a webinar, you can use the chat. Unfortunately, we cannot bring you in to ask in person, but please do make use of the chat already during the talk and afterwards as well. So we look forward to a stimulating discussion. Thanks so much, and over to you, Katharina.
Thank you so much, Georg, for this very kind introduction. So, and thanks all of you for coming today. I'm going to share my screen so I can show you some PowerPoints here. And so the project that I'm currently working on and that I was talking to Georg before this webinar is the laws of capitalism. And it's I was actually asked to do this to basically provide a more theoretical grounding for the work I've done in the Code of Capital. And I will tell you how I approach this issue. So I'm basically asking myself a puzzle. And the puzzle is this: why is capitalism, a system that is coded in law, as I explained in my previous book, so resilient to legal governance? So I learned the strategy for good research from Bob Putnam many years ago at Harvard. I took a seminar with him, and he basically said, if you really want to make a contribution to the literature, you have to find a really good puzzle to solve. So I hope this is a good puzzle. If it's not one, tell me, because I'm still writing the book, so I could change it. But the puzzle I've posed myself is, why is capitalism, a system that is coded in law, so resilient to legal governance? So let me this is the outline of my talk today. So I will talk a little bit about the previous book just to put you on the page. Then I will identify 3 laws of capitalist law. So basically the laws of capitalist law explain the puzzle, as I will argue. Then I will say a few words about the prospects for change. So which of the laws can we tweak and which of the laws can't we really tweak, or we have to think about other ways to deal with them. And then I want to apply this to the challenges of our climate problems that are coming ahead. And of course, if I'm arguing that capital is coded in law and that law can create both wealth but also inequality, then I also have to think about how law can be used or is being used in this context of climate change. And I will draw some implications at the end. So as I've argued in this previous book, capital is coded in law in a nutshell. Give me any object, any promise, any idea, and with the right legal coding, I can flip an ordinary asset, a simple object, idea, or promise into a wealth-generating, wealth-protecting asset, and that's capital. The modules or the attributes of capital that I identify in the book are priority, durability, convertibility, and universality. So I'm basically saying a set of legal institutions, which I will show in a second, can be used to rank claims to an asset. That's priority, most explicit in property rights. If I own something, have stronger rights than if you just have a contractual claim to the same asset. Durability means that I can extend these attributes or my rights in time or against different groups of potential claimants. Ideally, I want to protect assets against as many creditors as I can, and this is done mostly through corporate veils or the trust. Convertibility is kind of a liquidity guarantee. I can try to convert, or ideally I have a right to convert my assets into safer assets, especially in times of crisis. It's essentially the way in which financial assets can attain something like durability. And then last but not least, universality. The rights and interests that are legally recognized can be extended in space against everyone. So erga omnes. If I have certain rights to a thing, the legal system will help me protect these rights against anybody, not just my contracting party. So that's these are basically the qualities, the attributes that capital must have. And the legal institutions that have been used for centuries, again and again, although there might be others. So there's not one way to code capital, but what I found interesting is that whether you talk about land, about firms, about debt, about ideas or intellectual property rights, you find a roster of assets, of legal modules time and again. And these are property law, collateral law, trust law, corporate law, bankruptcy law, and then contract law, which can mimic many of the features that we find in the other legal modules here. So that was the core argument that I developed in my previous book, The Code of Capital, How the Law Creates Wealth and Inequality. Basically, just take a couple of assets, code them with the right legal principles, and then you can have a comparative advantage against everybody else. It's only comparative, it's not an absolute advantage, but that really makes a huge difference. So sometimes the coding of capital goes overboard. The clearest manifestations of this is when we have a major crisis, a depression, a financial crisis, or the like. And typically, or you have market structure changes, so you have monopolies. So there's not a natural equilibrium that we observe in the real world, but in the real world, we do observe that the coding of capital can sort of create certain types of social cost. And then what typically happens is that regulators come in or legislators come in and they can constrain the private activities. They can rein in sort of the scope of certain types of rights. They can also restrict standing rules to have access to the means of coercion to enforce them. So there's some tweaking sometimes with private law, but there's actually astonishingly little tweaking with private law institutions. Most of the work is done either through taxation, ex post redistribution when we talk about wealth, or you can also use taxes in a punitive sense. But regulation, of course, is the primary means by which some excesses will be reined in. And of course, how effective the regulation is depends in part on the powers granted to regulators, the resources given to regulators, and the ability of them to really enforce these principles. Sometimes we also use private rights of action, which can, of course, also be perverted again into assets in their own right, but they can also make the enforcement of public regulation more effective. examples in the US context where this is much more common than in Europe is, you can, under the Antitrust Act, you could sue for treble damages as a competitor who was harmed by a monopolist or oligopolist. And or in securities and exchange rules, you can have a private right of action because you were harmed by securities fraud. Things like that have been hashed out in the courts. Much more conservative, this type of action, of course, in Europe, as I said before. Now, the point I want to make is that the attempts to rein in these private coding excesses, if you wish, always diminish over time, and they diminish at an astonishingly fast rate. So what we see is that some of the regulations that are put in place are being rolled back either by legislatures or by courts, and we also see a fair amount of erosion through legal arbitrage. So one of the comments a lawyer I know has made to my students as well is basically saying we can mute most public regulations with the toolkit that I just talked about, the coding of capital. We can mute the public regulations, just take some time, and it also makes the world of financial regulation in particular ever more complex. So you have a crisis, the regulator comes back and regulates, and then you have to find ways to get around the cost of regulation while still formally complying with it. Otherwise, you're facing enforcement actions that complexifies everything, but still mutes the effects of regulation. So just to give you two, what I think relatively dramatic examples of how regulations that was put in place really didn't last all that long. So you might think that the New Deal in the United States or the new legal and regulatory frameworks that were put in place in European countries such as Germany after World War II, you might think that they lasted until the 1960s. I'm saying here, or maybe somewhat still into the 1980s. It's actually a long period of time, but in the grand scheme of things, it's actually not that long when you think about what really was done after World War II. So there were attempts made to really have a global regime for capital controls tied to a global monetary regime that was monitored by the IMF. That's begun to erode arguably already in the 1950s, certainly in the 1960s, with parties just figuring out how to use currency swaps and other techniques to get around them, the emerging euro-dollar market and things like that. And clearly by the 1980s, so this is 4 decades after the end of World War II, most of these structures were beginning to be reversed, full wholesale reverse, in particular in the United States and England. We know this through Reaganomics and Thatcher's politics, but so we're again in a mode then in the 1980s where capital reigns, and it's not only that sort of the toolkit hasn't really changed, but we're taking back the regulations that were meant to rein this in to some extent, and are actually celebrating the use of the toolkit to create private wealth. The other example is, of course, the 2008 crisis, a dramatic crisis. Many people compared it to the financial crisis of the early 1930s, excuse me. And we certainly had regulatory responses both in Europe and the United States, mostly again on a regulatory front, much less thinking about the source code that created the assets and the intermediaries that had sort of been put together for what we now call the shadow banking system or the parallel banking system. But as I said before, many of these regulations have been muted to some extent. We see many of the assets in slightly disguised form coming back. And also we see a lot of migration of techniques that were first used to securitize mortgages. We see them migrating to the balance sheets of ordinary corporations as well. I would make one exception. I think the largest banks have been quite effectively regulated. That also meant that they had to spin off many of their more aggressive activities into independent entities. So the entities or the practices as such did not go away, but sort of their locus with banks that were much more heavily regulated and therefore also have been become more safer. That sort of has worked, but in many other areas, I think we also have seen a lot of reversal in practice, if not in name, of the regulations put in place in the aftermath of the last crisis. So why is that? So I'm coming back to my puzzle. Why is it actually that a system that is coded in law is so resilient to legal governance? And what I'm basically arguing here is that there are 3 big principles, I call them the laws of capitalist law, that allow or make it possible to see this erosion of legal constraints. The first is, this is basically based in part on my own book, but also in part, of course, on Christoph Menke's critique of subjective rights. It's something that Max Weber has already articulated. So if you endow individuals with certain rights, they might, this basically means that they have access to the consolidated centralized means of coercion and can use them for their own interest. I think I would push a little further and say it's not only just about subjective rights in the way Max Weber defined them, but it's also about really individual legal entitlements. And an entitlement, I would say, is something where you have not only a subjective right, but you have no responsibility. You can use it in whatever, when you can shift or externalize, the economists would say, the risk of using this right to others. And so basically the freeing of the subjective rights and from most responsibilities, including liabilities, I will come back to that later, basically gives me what I would call a legal entitlement. So that's an important aspect, and how it plays out with the others, I'll say in a second. The second point is also one that I've made repeatedly when talking about the Code of Capital, is that, yes, the nation states have centralized the means of coercion, but it doesn't mean that we have only centralized access to the means of coercion. In fact, we have highly decentralized access to the means of coercion. And how we grant access to whom, on what grounds, and at what cost really makes a huge difference in terms of who can play with this legal system, who can advance their rights, and how are they doing this. And so litigation and arbitration, of course, are ways in which we grant highly decentralized access to the means of coercion. Individuals can sue on certain grounds. We can restrict this. We can make it more difficult or easier for certain types of claims, and we do that. And I think it will also take some review on, about who has these rights and who doesn't. So for that, of course, you have to have substantive rights. You have to meet certain procedure requirements, standing requirements, etc. And what remedies might be available also has a lot to do with what we can get. You see some of that play out in the climate litigations as well. I'll come back to that later. So how long it takes and who actually can make a claim against major polluters. You can see how we have constrained certain interests, but given rights to others in a way that they can protect their own. And so depending on how not only how decentralized access to the centralized means of coercion is, but who has on what grounds access to them is an important mechanism. And the last mechanism, or the last of the three laws of capitalist law that I mentioned here, is what I call legal arbitrage. And that has been, of course, a core feature of the coding of capital as discussed earlier. And that is that we can use the law and make it relatively malleable in how we apply it, how we interpret it, and how we can also use, let's say, private law institutions and mechanisms to get around public law constraints. This is, to some extent, a result of an inherent feature of all law, that it's relatively incomplete. So it's very difficult for contracts, we know this from contract theory, to anticipate all future contingencies. It is even more difficult, of course, to do the same for law, because law is meant to be general, last for a long period of time and cover all kinds of cases. And so you have already created, by creating a law, you have created the conditions for a lot of legal arbitrage, because now we can engage in, what is the scope of this law? Where are the boundaries? Can I get around it? On top of that, of course, we have a lot of regulatory competition, which is enhanced by the fact that we have made it easier to pick and choose laws from different jurisdictions by which those who have the means to do that wish to be governed. So by making basically law portable, we have increased the scope of legal arbitrage. So what I'm basically arguing, there's certain features of the legal systems that are prominent in capitalist systems that are actually at the very heart, at the very core of capitalist systems, that allow capital, the production of private wealth, to get around the constraints that are imposed on capital time and again. So this is the way in which I want to resolve the puzzle. Now, you could argue that each of these laws of capital law are already, quite powerful, but maybe on their own, they really wouldn't do the trick. They wouldn't make capital as resilient to legal constraint as it currently is. So I would say that the legal entitlements, the subjective rights but without responsibilities, they are very often the justification also to engage in legal arbitrage and get away with it, because I have this right and you can't take this right away from me, because that right might even be pre-law, pre-constitutional, because we are invoking natural law ideas of property rights. Therefore, I'm also entitled actually to engage in legal arbitrage and get the most out of it. Legal entitlements also means I have access to the means of coercion. I have these rights. There are these incumbent rights that have been around for a long time. Property rights, of course, being the most prominent of that. That also means I have to be able to enforce it in a court of law. And if then the legislator creates other types of rights later on, like the private right of action for treble damages, that's actually not such a great right. So that would be, of course, fought ideologically also on those grounds. But the idea of a legal entitlement sort of gives me also access to coercion is essential, and many courts would go along with that. And access to coercion is, of course, also a way in which I can manifest and sanction, expose the kind of legal arbitrage mechanism that I have created. So in an ideal setting, I can get them vindicated in a court of law. The arbitrage coding strategies that I have developed as a lawyer or on behalf of my client, of course, or I can also use legal arbitrage to avoid it or get courts to diminish access by others that might want to challenge my coding strategy. So I'm basically saying these three laws of capital laws, they reinforce each other. You have to look at them as a package that together they create the resilience against regulations, not necessarily each one on its own. We could probably get a better control of the excesses of capitalism if they were not a package deal, essentially. So what then are the prospects for change? Is this basically, then there's no way out, Niet východa, as the Russians said in the late days of the Soviet system. And I would say, well, we have to think this through, because there are some areas or some aspects of these laws of capital laws that are really hard to change. So I think one of the least amenable to change is legal arbitrage. I mentioned that already. Law is inherently incomplete. There is nothing you can really do about this. You can write more specific laws, but if you're very specific in the laws, you also open the doors for legal arbitrage, because then everybody knows exactly what the boundaries are to get around it. So in a paper I wrote many, many years ago on incomplete law, we basically argued with Changkang Xu that there are two important aspects of incompleteness. One is it's overly general law, very open principles. Nobody really knows what they are. And so there's a lot of gray area that we can exploit. And the other is sort of you write very sort of specific rules and then you can easily arbitrage around them. I would also say that if you want to have transnational activities of any kind, social, economic, etc., you need portable law. You need some way of people making sure that the agreements that they made in one country or the corporations that they created in one jurisdiction also have some validity elsewhere. Otherwise, you're creating costs that are unsurmountable, and then you're basically killing the transnational activities. And I'm not one who would argue in favor of complete protectionism or autarky. The choice of law harmonization that we've seen over the last couple of decades, which I think also was one of the sources for the kind of global capitalist system that we see, of course, evolved as a response to the enormous difficulty of harmonizing substantive law. And you can see this in the European Union. Attempts were made for decades to harmonize European Union law, more successful in some areas like consumer protection law, but less so, I would argue, in corporate law, for example. And so the choice of law became basically the second best of let's just harmonize those rules and then leave it to private parties to pick and choose as much as they can and want the laws by which they want to be governed. So it's hard to really play with legal arbitrage, although you can rein it in a little bit. And at least what you could do is think about, especially in the realm of choice of law rules, how much you want to enforce them or review them, at least at the enforcement stage. So the middle ground, I would say that here you can actually play and you can think harder about what one might want to do in order to ensure that we can get a handle over the excesses of the private coding of capital. Is one tinkers with the subjective rights, especially one tinkers, I should say, with the legal entitlements and brings them back to what one might mean by subjective rights, which means essentially rights for which the legal order, the society that sponsors the legal order, gives you a commitment that you can access the means of coercion. That's basically how Max Weber defines a subjective right. And I think that's fair. You should have that. And this society should decide which kind of rights you can bring, and you can have access to our consolidated means of coercion. I also think that subjective rights are fundamental for a liberal social order, and I sort of, I might come across as a progressive, but I also believe in some fundamental liberal, individual rights. So I think just they have a value on their own that should be protected. But we also have to make sure that the rights of some do find their boundaries in the rights of others. And this reflexivity, which Hanoch Dagan, for example, has written about in his recent book on a liberal property law, I think this reflexivity has just fallen under the table because we have put so much emphasis on these legal entitlements. So subjective rights have been turned into legal entitlements, and I think we have to roll this back. And we could by imposing more constraints on their enforceability and on their interpretation. So I think the avenue for change would be to say that all rights essentially are contingent. They're contingent on the rights of others. And that we also have to make sure that we internalize the cost of exercising these rights by also being clearer and harder on the liabilities. The system that we currently have allows for a lot of shifting of liabilities to others, a lot of externalization, which of course economists would tell us is inefficient, but it's the legal system's imbued with liability shifting, and the engineering activities those lawyers engage in are mostly dealing with sort of shifting the risk to others, shifting the cost to others, trying to ensure that their own clients face as little liability as possible. So I think reviving liability, there was a paper decades ago by Lynn Lapuki on the death of liability. I think we have to resuscitate liability, and some avenues would be piercing the corporate veil, of course, consolidation of corporate groups to look through and allocate liability, including tax liabilities. And one could also think more, inventively of, we know margin calls in the financial sector. You could also think about something like loss margin calls. If you pollute and pollute and pollute, maybe we can make a margin call on you if you cross certain thresholds to pay. What is most amenable to change? Well, of course, access to the means of coercion, because that's ultimately controlled by the polity. So when we talk about states, I think it's fair as a shorthand to associate states with access to the means of coercion, stipulating who, under what conditions, does have access to the means of coercion. That includes private and public actors. For public actors, we're basically giving them certain powers under certain conditions to impose fines or even sanctions, imprisonment on others, but this is reviewable by courts, etc. And for private parties, we do this too. Again, who has access to them? We can also change that. We can change standing rules. We can think about who should also have easier standing to enforce certain types of rights, and so create a more level playing field for different groups in society to mobilize access to coercion through different mechanisms. Litigation is not for all. It's not the only means. It's also a costly mechanism because it's highly decentralized. You have to have courts able to deal with a flood of litigation. We see in the United States that most people with relatively small claims basically have no attorneys anymore. The courts are overwhelmed. This is not really a justice system anymore. It's just a processing of claims. Many of them go really nowhere. So I'm not saying we should have more litigation. If we want to do this, we have to have different types of courts and also think about the payment of judges, but we also have to think about alternative ways of mobilizing access to the means of coercion. So let me say a few words about climate change. The one chapter in the book, which I have not drafted yet, but I'm working on, is sort of to use climate change as sort of the challenge for my theory. Both again saying, how does a legal system contribute to climate damages, and what could be done against that, and how could we make this more resilient? Because I think climate change is really the kind of challenge where we can't really tinker for too long anymore, because while social systems might be, expandable, malleable, and seem to be always expanding in some ways, natural systems are not. Natural systems are naturally bounded, and we're confronting the boundedness of planet Earth. So we have to think about very hard, I think, about what legal mechanisms might work. So I think that the three major principles for dealing with climate change would be, on the one hand, to think about who bears the cost for harm that has already been done. What about precaution as we think about the future? So the precautionary principle. And then how do we deal with the transition from where we are to a system that would be more amenable to and consistent with precaution and cost and loss sharing? So one of the principles I would argue is the capitalist system that we have created is one for perhaps some gain sharing, although I'm also arguing that there's a lot of private wealth creation that is not necessarily shared as much with others as we like to think. But the real challenge for climate change is actually loss sharing, not only gain sharing. So what about costs for harm done? Of course, nobody wants to talk about this. We have damages already that don't necessarily fall where they have been created. And through the mechanisms that we have, liabilities, as I suggested earlier, very often dumped on others, and those that should be held liable are not liable because we have limited liability and we have other ways to protect them. So I think we have to think about transfers, and not only transfers between states, but also transfers from private parties. You could also think about, profit sharing arrangements where people who have been seriously harmed by polluters would get a share in the profits of the big polluters. So I think we can be much more imaginative. If we were just as imaginative as the coders of capital in thinking about this, we could find more arrangements here as well. And of course, we have to think about cost sharing arrangements in a more serious fashion. What about precaution? I think many of the legal mechanisms that I discussed in the Code of Capital and that I briefly mentioned today as well are mechanisms that allow us to deal with fundamental uncertainty and pretend that there is no such thing as fundamental uncertainty, or sort of that we can manage it. In the finance sector, people want to manage risk and they use probability calculus in a fancy way with that. But of course, ultimately, we face fundamental uncertainty. We don't know what the future will hold. We don't know exactly when the cost of climate change will come upon us and how big they really will be. Given that we don't know and we cannot know, we've tried for decades to find the right discount rate and other things, and to not too much avail. I think we have to just make uncertainty real. So basically soften the kind of legal mechanisms that we have created to enable people to make high bets on an unknown future and say, well, those bets we can no longer make because we have to work within a precautionary principle. So we have to think about how to prevent future harm. We have to move from legal licenses for externalization, which is what limited liability is all about, to forcing entities and investors to internalize losses. We have to think about loss mutualization and maybe even liability options of the kinds I mentioned earlier. And then the transition. Most people who are talking about the transition are thinking about how do we finance transition? And then the logic argument is to say, well, the governments can't do it on their own, so we have to get the private sector to finance transition. But I think it's also important to think about, who's actually bearing the cost of transition. Because the financial sector will not bear the cost of transition. They will make everything, and that's when we look at how it has evolved, why it's so profitable, why it's so effective. It's been so effective because it can shift the cost to others, in the last instance to societies that bail out the financial system when it starts to tank, and that we have seen this in 2008. We've seen this again in 2020 under the COVID, and I see no reason to believe that this will be different when climate change hits. So I think we have to have at least a different perspective, complementary, and ideally, I think a different one that says, okay, how do we allocate the cost of transition? Who should bear the cost? Ideally, those who actually are able to bear the cost. So I would say more those who have already a lot of wealth and capital, not necessarily the needy, but of course it will be the other way around unless we do something about it. I should just mention one example. I had a former student in my class the other day talking about the main solar market. And the main legislature has actually been able to at least shift the cost of future legal change and changes in the marketplace that they wanted to enact onto the investors rather than onto the customers. And so being smart about that is, I think, really important, and lawmakers should think about this very hard. So the mechanisms for dealing with transition, we're trying to put our bet again on asset markets, right? Kelly said this after the COP26 in Glasgow, the private sector should do it. It won't, right? It will contribute to some, to some financing certain types of activities, but not necessarily in a way that we can know and and reliably know and bet on that will actually mitigate climate change. You just have to read the Financial Times every day and see. Today I read about, is shorting. Can you use shorts of big oil companies as basically as an offsetting mechanism for carbon? And then of course you're doing a financial hedge, but you're not doing a climate hedge. Seriously, we have to think about insurance, of course, and public investments here as well. So I don't think I have much more here. I haven't really talked about the implications. I think the implications are pretty obvious here. What I'm saying is that when we look through the mechanisms of both creating wealth through law and the difficulties of reining in the mechanisms that we have created through public regulation in particular, but also through taxation, we probably have to alter the system more fundamentally, because unless we if we leave the laws of capitalist law in place, then I think we're just going to play the same game that we've played in the past, and it won't allow us to deal effectively with the challenges that we face. So let me leave it here. I think I'm slightly over time. I apologize for that, and looking forward to your questions.
Thank you so much, Katharina. This was a very, very fascinating talk, almost 3 talks in one, if I may, right? So the brief 2-minute summary of the Code of Capital, then a fascinating new book, and then some bonus material on climate change. So I think the students got 3 keynote addresses in one, and it's been, I could listen to you, I guess, forever. But we have some questions already in the chat, and I would encourage everybody to make use of that. I have tons of questions myself, but I think we should turn to some of the questions in the chat. There's one from Boudewijn Boekert, well, several of them, but maybe the first 2 ones are connected. So he asks about the notion of subjective rights that you use, Katharina, right? And saying that, I think, summing up his point is that subjective rights are always inherently limited, at least in law, So through tort, through nuisance, through basically legal philosophy, that subjective rights can never be unlimited. That's at least our basic understanding. So what's your take on that?
No, I think, philosophically, certainly this is right. And which is why I'm also saying I think the deeper problem is not so much the subjective rights as such, but the creating of subjective legal entitlements. And that I define as subjective rights stripped of the kind of responsibilities. So yes, you have tort, but if you have limited liability, you're protecting certain types of investors from tort liability, right? That's the whole idea. So we have, I think, in many ways in the capitalist legal system, ways to escape the kind of responsibility that comes with it. And when you think about the interpretation of property rights, including the so-called property rights of shareholders, where we could have a debate whether this actually are property rights and should be treated as property rights, but they have been. So the logic of a system that is trying to expand the notion of, I think, really legal entitlements, this is mine and you can't touch it, sort of this exclusive dominion that Blackstone and others have talked about. The law very often is much more nuanced, and I think Hanoch Dagan has pointed this out, but when you look at the specific structure of financial instruments, of corporations, of other legal tools, you can actually find that we have created a lot of these legal entitlements. That's what I want to roll back. So I'm not saying abandon subjective rights. I want to go back exactly to this philosophical notion that they could be bounded by the rights of others.
Okay, great. And then there is a question from one of our students, Ringe Palacios, who asks whether you think that any change in the law of capitalism may come out of the pandemic. So whether the COVID-19 scenario changes the analysis somehow.
I think many people thought that this would happen 2 years ago when the pandemic hit. I also helped edit a book that Columbia University, the law school, put out on COVID, and people were talking about sort of how there would be no sort of sharing arrangements and how the bankruptcy law would change, etc. And I think this was a short-lived hope. I think there are some, really stark reminders that we're not doing this. We're not doing this on intellectual property rights. Right, the big pharma companies were able to negotiate privately, secretly with different governments and get their deals and get their property rights protected, even though we're putting the entire world at risk if other new variants come up in places where people have not been vaccinated. So if there was, one example where we could have tested, are we able to do, mutualization of costs and of losses and sharing, it would have been how we share the COVID vaccine. And if you look at that, it's actually quite depressing, right? There was an article yesterday that Europe has sort of had to destroy a lot of this COVID vaccines because it had expired, but rather than shipping it to others who would have direly needed it, the kind of waste that we allow to happen is quite stark. So I think, unfortunately, no, we have sort of propped up the assets in fear of financial calamities. Some good stuff had happened. I don't want to downplay everything. I think governments have gone out and reached out to parts of society that they did not reach out to immediately after the big financial crisis of 2008. So, subsidizing households, subsidizing in one way or another workers also in small and medium-sized enterprise was a good sign. I think with the concerns about inflation right now, there is very little appetite to think about how to do this in the long term, even though this is the kind of insurance that we probably need to get through the next climate disasters together.
Great. The next question comes from Giangarello, who asks whether you would be in favor of abolishing limited liability of corporations.
I have made that point. I was at Davos 2 years ago, and I mentioned this because one of the issues that came up in these debates about ESG is that the investors just don't know how to price it. And so I said, well, let's help them. They can't know how, the investors don't price climate change or other factors in ESG because they don't bear it. If you don't bear it, you won't price it. Right? So if you strip limited liability out, they will have to think about under what conditions they might actually get hit with liability. I'm not the first one to say that. Huntsman and Kratman have written an article in the 1990s where they said we should move towards stripping limited liability for tort, and pollution would be a tort as well. So I would be in favor of that. We can debate whether we should do this also for contractual liabilities, but I think certainly for tort, and we could start with an experiment to saying, well, for known polluters that continue to pollute, the big oil, where the prices are going up right now, everybody's moving back into brown assets right now, just make clear that you will be hit with a liability. You know exactly what you're doing as an investor. And so you have to do two steps. You have to make sure that these companies really face liability, and then you have to say in the liability that the companies won't be able to pay. Or they have structures where they have subsidiaries, etc., so that they will bankrupt and then continue as if nothing had happened. We will go through and we will pierce the corporate veil and go to the investors. I think this would be a good thing.
Wow, I guess then we would have no big oil from one day to the next. But
no, it's a question of we have, of course, you would have joint and several liability. It's a cost sharing thing. But I think if you want the market to work seriously, you also can't not only think about how to create more gains. You have to think about how to allocate losses. Would be one market mechanism.
Right. Next question is from Nancy, asking how would the issue of mandatory vaccination or payment for risk be analyzed under the light of the Code of Capital?
Yeah, I don't think I have a real framework now for mandatory vaccination in this, because what I'm showing is actually more how aspects of the legal system can be used to by private parties to create private wealth in the shadow of state action. So I'm less concerned with mandatory regulation across the board, including mandatory vaccination. However, I think sort of this notion that all subjective rights are bounded by the rights of others and gives you a handle, and that's sort of an old philosophical notion, as the first questioner already suggested, is basically to say my freedom to infect others is limited, right? If I have an infectious disease that could possibly be lethal for others, my right not to wear masks must be bounded, right? And so and states, the role of states is to make sure that people are protected in one way or another. So I think you can, from the logic of the arguments of I make, you can draw some inferences about these issues as well.
Cool. Then we have a question which I find very interesting on cryptocurrency. Look, this is a new asset class, if you like, a new test case for your theory. And well, it's been coded, right, somehow. So it is something that we've invented. And so how does that sit in your framework? And the distribution and speculative effects that everybody's talking about at the moment. Unlimited by, I mean, you know, it's a prime example, arbitrage everywhere, the limits of national laws everywhere. I mean, you know, this really fits bang on onto your theory.
Yeah, absolutely. So, and I have a chapter in my book about the digital code, and I asked the question whether the digital code might replace the legal code, at least in certain parts of life. And I think the cryptocurrencies are a very good example, although when you look closer, you can also see how the legal system plays into that. You know, many of the cryptocurrencies were first created under Swiss law. Why? Because Switzerland basically opened its doors for doing that and made it much easier for companies to go there. Now, what very often happens, they do find the Swiss market a little bit too small to really succeed. So they want to come back to the American market. And then the question is, shall they be regulated? Are they actually a security under the Securities and Exchange Act or the Securities Act? Is this actually just a disguised banking activity, and therefore they should be subject to banking regulations? So I think this is a new form of arbitrage because it combines legal arbitrage with digital technologies. And I think the digital folks thought that they're outside the law, but you know, you are actually never really outside a social system that will think about the risk that you're creating, and you're also not outside just, you know, taking advantage of the legal system as it exists. So I think this is as you suggest, a really interesting space where you can see the attempt to carve out a space where you can do things without any kind of legal interference, while at the same time taking advantage of the law, because you're choosing where you to incorporate. You're using corporations to limit your own liability. You're using contract law to impose certain liabilities on others. Then you also write commitments on blockchain, right? But we also have to realize, I think, in this regard, what the limitations of blockchain and other digital coding mechanisms are. Under conditions of fundamental uncertainty, we will always have to go offline sometimes, right? When we have not foreseen future contingencies. And so how to govern that and what is the role of law as a default is also a very interesting space to think through.
Okay, we have a follow-up question to the limited liability point made earlier. So one panelist asks whether recklessness as a liability standard would be an alternative to get a solution as opposed to requiring fraudulent conduct.
Yeah, so I think, so this is, I think when we say we want to strip limited liability for tort action, then I think we do face the question of what is the relevant standard of the subjective standard of either intent, gross negligence, or simple negligence. And I think it probably makes sense to limit it to gross negligence or recklessness rather than just negligence of the corporation that then sort of feeds through to the investors by default. So that's something I think to be hashed out. I think what is really important is to make the point that, yes, we invented limited liability at a time when we had scarce capital, and we're trying to have, you know, capital intensive investments in coal and steel and all railroads, etc. That was sort of a wonderful invention, but it created huge cost, huge externalities. So maybe we cannot afford this anymore. And then how to tinker with this and how to think about the transition, how to phase this in, I think is something that we should discuss.
Great. Now comes one of those big questions. So it's from Baldwin again, and he asks, you know, the government is omnipotent somehow, can do everything, can tax, can regulate, expropriate without any limits. But you seem to suggest that powerful interests somehow always gets away with it. even irrespective of the government. So what's your explanation? What's your framework? Is it a public choice story? Is it a pragmatism story? Is it a networking idea?
Yeah, I'm basically trying. This is why I went into this. The laws of capitalist law. I'm basically saying, why is it that capital gets away with it? It's a system coded in law, and yet it's not. It is very resilient to legal governance. And you could tell a story about, capture, collusion, corruption, all these things. And I'm trying to avoid that. I think there's always some of that involved. So I'm trying to explain sort of more structurally what are the mechanisms by which you can get around it, assuming for the purpose of the argument that both sides are basically doing what their jobs are. Right? The government is essentially trying to rein in, which of course is also not true in many cases. The government is also often involved and may also very often being captured. I don't think it's all powerful in all cases. In fact, we know sort of financial dependencies and electoral systems and But assuming for the purpose of the argument, that's basically where I start, that governments govern and the private sector is trying to create wealth. And if we within those, under these assumptions, could you still have the outcome that we observe, is that capital gets away with it? And I'm saying yes, because the way these three laws work and interact with one another, the legal entitlements that we have created, the legal arbitrage, and in decentralized access to the means of coercion give you the power to do so. And then when you add the other things, you can have exacerbated effects.
Cool. Let me ask a personal question. So your framework largely applies to the capitalist societies, and it somehow seems to be working particularly well in democratic societies as well. Mm. So my question would be, what happens if you look beyond, particularly to more authoritarian regimes, aka China, for example, right? So are those parts of the world also in the process of falling into the same trap, according to your view, in basically introducing capitalist or quasi-capitalist reforms at the moment that are opening up exactly the same Pandora's box that you observe in Western societies? Or is there anything that authoritarian regimes do different, that they block, that they do not allow to happen, so where they distribute wealth differently?
So I think they try to guard themselves against instability. That's China has done that. And you could see this already in the 1990s when they didn't open their borders to capital flows, and they survived the East Asian financial crisis much better than anybody else. I think the Chinese regime, including the Communist Party, know very well that finance is a spot of potential destabilization. And the last thing the Communist Party wants to have is destabilization. And so I think they guard themselves by different means. And there's also like a spectrum of relative authoritarianism and democratic systems. So I think for China, the classic example is what happened with the Ant IPO, right? So they just said, no, we just don't allow you to do an IPO. It goes too far. If you go into our payment system in that level, this just goes too far. We're not allow this to happen. And so I'm not.
But allow me to interrupt. But the question now is, did they go too far there? They harm themselves.
I think that's of course, we always make
have they already set everything in motion already so far that they cannot close the Pandora's box anymore? Mm.
That might happen. So I think China, in order to grow, right, has created all sort of these the same possibilities to some extent that we've had here. I mean, Dan Ori has talked about the Chinese shadow banking system. It exists there as well because we train all the lawyers in the US and tell them how to do this, and then they transpose these techniques to China and do it slightly differently, but they can still do it. And then at some point, the Chinese government wakes up and says, well, this goes a little too far. So I think they're trying to keep a lid on this. It's difficult. It gets really complex because the more you decentralize, of course, the more the harder you have, the harder the time is you have to rein this in again. So I was just also thinking in the back of my mind about countries like Singapore, for example. They use different mechanisms to protect themselves. I think an important mechanism for Singapore has always been these sovereign wealth funds to have basically just an insurance mechanisms for rainy days. And but there's a different mix of what you can do or can't do, and they attract capital, but they also protect their societies through other mechanisms so that they're not dependent on outsiders exclusively if the system tanks.
Okay, so there are more questions. We are slowly coming to the end, but I'd like to pick up Priscilla's question on what is your perspective on the Foreign Investment and National Security Acts to protect strategic areas of countries, to shield them against foreign influence?
Yeah, I mean, it's always it's a hard call, because it's a question is, what exactly falls into them. It could be just another mechanisms to become very protectionist about certain types of things. I think one of the things we have learned from the COVID pandemic is that just relying on global markets for goods and services and pharmaceuticals is probably risky. So I think many countries have to think about whether sort of the fragility of international supply chain is something that is sustainable under conditions of also increasing climate change calamities, right? So you have more storms and you don't have to block the Suez Canal necessarily, but you could easily imagine other conditions why that doesn't work. So thinking about what kind of production has to be at home and how to ensure that you can, feed your population, and you can make sure that there's electricity and there's gas or other forms of energy, I think is something that governments will have to increasingly think about. It's just sort of this illusion that everything could always be bought on international markets, and therefore we can, we don't have any kind of protections for rainy days anymore, or think about how, the security apparatus is protected against foreign intrusion, which could, of course, include spyware, and so all the debates about the Chinese digital technologies come in here. It's a complicated question, but I think ultimately it's a balancing act in how much we want to take advantage of both trade and investment, and how much and what are the priorities that we have. And that's a normative question. What are the priorities that we then basically say we have to make sure that there's enough of this particular stuff at home to make sure that we can work for the people that elected us.
So there's just one thought, but it just occurred to me that at the last EMLE midterm meeting a year ago, we had Guido Calabresi delivering the keynote speech. And this was the time, if everybody remembers, when vaccines were not readily available everywhere. There was almost like a fight for them. And he asked the question why, and this is why I bring it up, why we didn't trust the market to do that job. So his point was rather that actually, it's hijacked by countries. Countries are racing to buy up vaccines worldwide, and they're specifically not leaving it to the market to do the job. And now you say the opposite somehow, that it was a bit too much left to the market.
Well, I co-edited and co-authored a piece in a book called Governing Access to Essential Resources. And we talk mostly about water in that book, but I think the pricing mechanism doesn't work for certain types of products that everybody needs for their survival, because those who have more money will buy it. And whether these are governments and states, and there's sort of a quasi market, if you want, or whether these are big companies or big wealthy investors who will get their vaccines. And of course, they did this already before we had the vaccines. The wealthy flew to Saudi Arabia or other countries where they were available, whereas everybody else here was standing in line. So I think for these kind of essential resources, you probably need a kind of a quota system. It might be inefficient, etc., but you can't possibly argue that you can drink water or get a a vaccine that happens survival only because you can pay the price for that. I think that's morally wrong. The mechanisms to make sure that everybody has access to them, that's a different story. And I think we failed on that. Both governments and the markets failed. But when you start with monopolist pharmaceutical companies that were actually subsidized to produce the vaccine, you can't possibly say this is a natural market out there. And then they can ratchet up the price and everybody has to try to get it. And if you don't, just too bad.
Fantastic. Look, there's one final interesting point from Mohammed Rashwan, who asked, what is your view on institutions that are not regulated, like governments themselves? He brings the example of the US military, which is a significant contributor to climate change, he said. Other example might be state-owned oil firms or something around the world. That is a different animal, right, in that thing.
Well, ideally, it should not be. I mean, I think ideally, you don't want to actually, the idea that governments are not regulators is, of course, crazy, because governments are constructed by law and legal institutions. And how we do that is also a question that could easily be changed. And the military how it invests and where it resources what it does is also subject in principle to Congress, which could, of course, impose certain liabilities. It's a question whether or not they're doing this. But to think of the government as a space outside the legal system, I think defies everything that we've tried to preach since the emergence of constitutional democracies. They're bounded by law, and the sovereigns are the people. It's not the state as a persona, and not the military either. That's an ideal, of course, but the question is whether we can realize it.
Fantastic. So it's all law, stupid. That's the that's the bottom line. Look, thank you so much, Katharina, for this wonderful talk and for being available to answer questions and comments. And it's been wonderful to listen to you. I think everybody had a wonderful time and intellectual fruit cocktail to think about for the next days. Thank you so much. And
thank you for having me. I really enjoyed it.
All the best for your book project, for your next books, and all the other books that I get to come. We wish you all the best. And
thank you for having me.
Yeah, thank you. And thanks everybody for joining. We have a little break now in the program, and we reconvene at 3:15 European time. So in roughly 12 minutes. See you then, and thanks, Katharina.
Cheers.
Thank you.